Ladies and gentlemen, Saidati, Vasadati, Signoras e Signores, Devio or Surgeono. Salam alaikum, Jamian. My name is Ajay Thomas, and I currently serve as the Registrar of the Oman Commercial Arbitration Center. I have the honor today of being the moderator of this webinar. So on behalf of my colleagues at the center, a very warm welcome to this exciting event. Marhaba. Ladies and gentlemen, I now have the great pleasure to invite Dr. Moosa Al-Azri, the Chief Executive Officer of the Center, to deliver his inaugural address. Dr. Moosa, over to you.
Thank you, Ajay. Distinguished webinar speakers, Mr. Sultan, Al-Abdulla, Mr. Sriram, Panchu, Mr. Gordon, Nardell, Miss Sherina, Petit. Ladies and gentlemen, on behalf of the Oman Commercial Arbitration Center, it is my privilege to be extending a very warm welcome to all of you to this webinar. This event will be the first in a series of webinars to be hosted by the center and various facets of arbitration and mediation. I am indeed extremely grateful to Sherina, Sultan, Sriram, and Gordon for having taken the time from their extremely busy schedules to be with us today. I do hope that at some point in the not too distant future, I will be in a position to welcome you in person to Oman and the OAC. As an institution, we firmly believe that institutions must play an important role in creating and fostering interest in an arbitration and mediation, and also in promoting best practices amongst arbitrators, mediators, lawyers, and end users of these ADR processes. And this webinar is a manifestation of that belief. The theme for today's webinar is very interesting: arbitration and mediation, straying, bedfellows, or compatible partners. Our star cast of speakers will focus on how mediation and arbitration can be made to complement each other. They will also discuss various hybrid methods of dispute resolution like arb-med-arb, arb-med-arb, and give you an insight into the mechanics of these processes as practiced in their respective jurisdictions. Let me take this opportunity to let you know that although the center is named Oman Commercial Arbitration Center, the center not only administers arbitrations, but also mediations under our own arbitration and mediation rules. One of the interesting aspects of the OAC mediation rules is that it provides for the mediator to propose to the parties that the matter be referred to arbitration or expert determination in those circumstances where the arbitrator believes that issues in dispute between the parties are not amendable to resolution through mediation. Given the most of you would be attending an OAC event for the very first time, let me give you a very brief introduction to the OAC. The evolution of arbitration and mediation is at a very nascent stage in Oman today. However, in recent years, there have been a number of positive developments in the alternative dispute resolution space in the Sultanate of Oman, one of which is the establishment of Oman Commercial Arbitration Center. The Oman Commercial Arbitration Center, or the OAC, is one of the most recent additions to the ADR landscape in the Middle East. The center was established by royal decree. By royal decree as an independent legal entity with full administrative and financial autonomy in its operations. We aim to provide an institutional mechanism to ensure the expeditious, cost-effective, and totally neutral administration of arbitration and other forms of ADR to local, regional, and international parties. I am delighted to inform you that the OAC has now become fully operational from our brand new premises located in the heart of legal Muscat, adjoining the Supreme Court of Oman. Besides offering state-of-the-art hearing room facilities, the institution will administer arbitrations under its own arbitration rules, supervised by a multinational secretariat. The institution is now administering its first few arbitrations and mediations, with total sums in dispute close to $35 million. Whilst this is not a bad start at all, we look forward to receiving a steady stream of cases in the not too distant future, and to establishing the OAC as one of the more preferred ADR centers in the GCC and also the wider MENA region. Therefore, I believe that with the growing popularity of arbitration and mediation in Oman and the establishment of the OAC in the months and years to come, there will be great opportunities for those who practice this branch in the law. May I take this opportunity to thank you all, the distinguished speakers and the participants, for participating in this webinar and thus contributing to its success. In closing, all I would like to say that given the topics and the profile of speakers, I believe the stage has been set for what promises to be a very acknowledgeable and exciting webinar. Thank you all, and shukran jazeelan.
Thank you, Dr. Moosa, for that very insightful and crisp introductory remarks. So, ladies and gentlemen, the topic for today's webinar is arbitration and mediation, strange bedfellows or compatible partners. I'm quite sure your first reaction will be that this is a very interesting topic. And to add on to that interest, ladies and gentlemen, I would like to let you know that flowing from this topic, it was said not too long ago that mediation is mediation and arbitration is arbitration, and never shall the twain meet. I'm taking a bit of poetic license here. But however, ladies and gentlemen, in recent times, these rigid boundaries between the two processes have begun to blur. And this webinar will, amongst other things, look into the myriad ways in which the processes of arbitration and mediation could be blended into one seamless dispute resolution process. And to take you to this fascinating topic, we are extraordinarily privileged to have with us today a very illustrious and diverse cast of speakers. And before I were to introduce them to you, let me very briefly tell you about the format for today's webinar. Our distinguished speakers, 4 in all, will kickstart the discussions by delivering very brief introductory remarks. Once all the 4 speakers have spoken, we shall then have about 25 to 30 minutes of open forum discussions. And that's the time we will also take questions from the audience. And for questions, ladies and gentlemen, you are requested to use the question and answers box on the Zoom control panel at the very bottom. So please use that control panel, the question and answer section, to send us any questions that you might want to put to the speakers. Do this during any point during the course of the webinar, and please do not necessarily wait until the opening of the open forum discussions. As a matter of fact, the earlier you put the questions, the greater are the chances that we'll be in a position to actually take up those questions. So now, ladies and gentlemen, done with the format, back to the stars of today's webinar. Here's a very brief insight into the star cast of speakers today. So what I intend doing when it comes to the bios and CVs, ladies and gentlemen, I am going to start in the East and travel to the West. So our easternmost speaker is Sriram Panchu. Now, Sriram Panchu is a senior advocate practicing at the Madras High Court. Madras, as you know, is today called Chennai, and it's in the southernmost part of India. Sriram is also an internationally recognized mediator. Over the last 2 decades, he has been instrumental in bringing mediation into India's dispute resolution system, working with senior judges, government, and business heads. In 2005, he set up India's first Court Annex Mediation Center at the Madras High Court. He has mediated a large number of complex and high-value commercial disputes and has to his credit some of the most noteworthy mediation settlements in India. Therefore, ladies and gentlemen, it is no surprise that in regional legal circles in the subcontinent, Sriram is very often referred to as Mr. Mediation. And Mr. Mediation has trained over 1,000 mediators over the years, and he's also a very prolific author. And his 3 books on mediation, Settle for More, Mediation Practice and Law, and Commercial Mediation Monograph, are considered to be authoritative guides on mediation in India. So, ladies and gentlemen, from Chennai, India, we travel west to the golden sands of Qatar and Doha, and Mr. Sultan Abdulla. Now, Sultan is one of Qatar's most eminent lawyers. He is the founder and managing partner of Sultan Al-Abdulla and Partners, a full-service law firm. Prior to establishing his private practice, Sultan worked with Qatar Petroleum for more than 22 years. In his private practice, he has counseled and negotiated on behalf of local and multinational clients, major transactions, projects, and his current focus is on litigation and arbitration. As part of his arbitration practice, he has represented numerous entities in local and international arbitrations. Additionally, he frequently sits as an arbitrator. He's an arbitrator on the ICSID panel of arbitrators and is an elected member of the ICC's prestigious International Court of Arbitration. He has an LLB degree from Beirut Arab University and an LLM in International and Comparative Law from the Southern Methodist University in the United States of America. Now, ladies and gentlemen, Sayyidati wa Sadati, we now move on from Doha further west to Her Majesty's England and to 3 more, London Riverside and Sherina Petit. Now, Sherina is a partner at the London offices of Norton Rose Fulbright, which, as most of you would be aware, is one of the leading international law firms. She leads the international arbitration practice of the firm across Asia, Europe, and the Middle East. She has significant experience in international commercial arbitration, investor-state disputes, alternative dispute resolution, and litigation. In addition to acting as counsel, she regularly sits as arbitrator. She is also on the board of the London Court of International Arbitration, the LCIA. She is a member of the ICC India Arbitration Group and also the SIAC Users Council. And very interestingly, she also acts very enthusiastically as a mentor for law students, being part of the mentorship program at the School for International Arbitration at Queen Mary University, London. and also at the Institute of Transnational Arbitration at the Center of American and International Law. Now, ladies and gentlemen, from 3 more London Riverside, we move east via Tooley Street, across the Thames, via London Bridge, on to Cannon Street, Fleet Street, the Strand, and on to Essex Street and Gordon Nardell. Now, Gordon is a Queen's Counsel. He's a member of 20 Essex, one of the most preeminent barristers sets in London, specializing in commercial arbitration. He's also a part of Alpha-Lex Avocats in Brussels. He handles international arbitration and cross-border litigation as a counsel and arbitrator. Gordon's practice spans Europe, Asia, and the MENA region, and much of his work involves disputes with governments, public bodies, especially in energy and infrastructure related sectors. He was a member of the drafting group which produced the CI-ARB 2021 Professional Practice Guideline on the use of mediation in arbitration. He, as a practicing member of the Bar Council of England and Wales, is a member of the Bar of England and a foreign lawyer member of the Dutch Brussels Bar. Now, ladies and gentlemen, on the very brief introduction of a star cast of speakers, I now invite our speakers to deliver their brief preliminary remarks. The running order for the delivery of these preliminary remarks will be as follows. Sherina will be first off the blocks, followed by Sultan, who will hand over the baton to Gordon. And finally, we'll have Sriram to take us to the finishing stretch. So, ladies and gentlemen, without further ado, I hand over the floor to Sherina Petit. Sherina?
Thank you very much, Ajay, for the introduction. It is my honor and privilege to have been invited by you, Dr. Moosa, and the Oman Arbitration Center for this inaugural seminar, and for placing me amongst such distinguished panelists. I know the time is short and you've asked me to address the topic. Whilst mediation and arbitration are fundamentally different dispute resolution processes, how can they be made to complement each other? And to address this, I thought I would go through a couple of subtopics. So one is a few words about arbitration and mediation, then moving on to some influencing factors, and then moving on to considering mediation during the life cycle of a dispute, and finally touching upon some hybrid ADR mechanisms. So let's move on to the first point, arbitration and mediation. They're both forms of ADR, meaning that they are alternatives to lengthy, costly battles fought in court. A mediator helps parties negotiate a settlement that will satisfy all parties, but a mediator does not decide a dispute. An arbitrator, on the other hand, functions more like a judge, deciding the outcome of a dispute based on evidence and law presented in an arbitration. Arbitration is final, binding, and enforceable, just like a court order. Mediation and arbitration are therefore similar in that they bring together parties in conflict to resolve an issue outside of the courtroom. But each has its own unique way of doing this. Therefore, they are certainly capable of complementing each other, but it ultimately depends on the individual parties and their actual attitude towards settlement. So let's move on to the influencing factors. Commercial parties are often than not considering using a combination of both a single dispute, but there are many factors that influence a party's decision making. For instance, you look at the nature of their relationship with the other party, you look at culture, and I know we're going to touch upon that later in this webinar, as well as the value and the complexity of the dispute. In fact, in one of my mediations over a supply agreement, the other side was only one of about 3 major suppliers of a particular part in the entire world. And therefore, to get into an aggressive arbitration with one of them would have ended up for my client to be very commercially damaging. So although in this particular case, the arbitration had been launched, we ultimately went in for mediation and settled through mediation. So let's move on to the next subtopic, which is the life cycle of a dispute and when does mediation come in. According to me, there are a number of instances during the life cycle of an arbitration that parties consider mediation or settlement. In this instance, I will touch upon an institutional arbitration with a traditional timetable rather than a memorial style timetable. According to me, I would think the first opportunity is usually before the formal arbitration is launched. The next opportunity is after the service of the request for arbitration, but before the payment of the large advance on costs, as now the respondent knows that the other side is actually serious and they will have to start digging deep into their pockets. This is usually, in my experience, followed by an opportunity after the close of pleadings, because both parties by this time know the other side's case, and they also know the next phase is going to be disclosure. That's going to be expensive and long, and potentially damaging documents may have to be disclosed. Another attempt is usually discussed during or after the service of witness statements, as parties have to sign statements of truth. So any bravado that may have been expressed in pleadings is tested completely at this stage. And finally, before or sometimes during or even after the hearing, depending on how the hearing has gone. It's not uncommon where, I've had to actually stand down an entire hearing because parties have not wanted to actually go on to that witness stand and be cross-examined. I've actually had one dispute where we were actually disputing over one potential agreement, but there were approximately about 10 different potential disputes that could have been launched between both those parties. And on the first day of hearing, we went into a mediation and we asked the tribunal, who actually had appeared at the hearing, that the parties had decided to try and mediate this. And not only did we mediate that particular dispute, but we actually mediated 10 of the other potential disputes as well and managed to settle it, standing down the entire arbitration. And I'll move on to the last subtopic, which is hybrid ADR mechanisms. It's important to note that mediation and arbitration further complement each other through these hybrid ADR mechanisms. What are they? Some of them are called med-arb, where parties would first attempt to collaborate on an agreement with the help of a mediator. If the mediation ends in an impasse or if issues remain resolved, the parties can then move on to arbitration. The mediator then assumes the role of an arbitrator, if they're qualified, and renders a binding decision quickly, saving the parties both time and costs by eliminating the need to start arbitration from square one if mediation fails. The advantages of med-arb are therefore that 1, it is time and cost effective. 2, it effectively is particularly effective when parties are under time pressure. 3, when they have an ongoing relationship with the other party for the future. I refer you again to the example I mentioned earlier. And 4, it also provides parties with inherently more control than arbitration, as issues agreed during the mediation could be excluded from the arbitration. So in fact, the threat of having a third party render a decision in a binding arbitration often inspires disputants to work hard in mediation to come to an agreement. There are, of course, pitfalls, which I unfortunately do not have the allocated time to get into just now. But for me, a fundamental, important and practical one, besides potential issues of bias, is a concern of confidentiality. It's a concern that if confidentiality of the mediation process is lost, where the mediator also acts as the arbitrator, parties would then feel uncomfortable probably sharing confidential or sometimes even damaging information or documents with the mediator in the knowledge that they might move into arbitration, and the information or documents could then be used against them. Further, for some parties, there may also be a tendency to use mediation to influence the would-be arbitrator. Any of these approaches to mediation would then go against the absolute spirit of mediation and would in any event limit how effective the mediation process would be. It would be incomplete of me not to mention that there are other variations of med-arb, such as arb-med, arb-med-arb, which can be used, especially where the parties would benefit from having a greater understanding of its own and its opponent's case by commencing arbitration proceedings prior to attempting mediation. These hybrid mechanisms are by no means new, but I have seen them increasing in popularity because they're offering parties flexibility. And in that, they will have the opportunity to structure and control their own resolution via mediation, but also the certainty that if an agreed settlement is not reached, their dispute will be resolved by a binding award. Ultimately and arguably, these hybrid forms do complement each other in that parties are always free to agree to any mix of mediation and arbitration via contract to suit their own relationship, to suit their business needs. And despite issues with cross-border enforcement, it is likely that we may see increasingly these disputes resolved using a mix of both. I think my time is up, and so I will just conclude with an interesting statistic which highlights the complementary nature of mediation and arbitration. It is estimated that approximately 90% of disputes that are finally submitted to mediation actually do settle amicably. Interestingly, I was reading a statistic in the US where ADR was used, and I read that apparently 65% of cases settled, only 29% of cases settled when ADR was not used. 65% settled when ADR was used, and significantly more cases settled when ADR was voluntary than when it was mandatory. So that's 71% versus 50%. I rest my case.
Thank you, Sherina, and especially for giving us that insight into those very, very interesting statistics, which only goes to show how effective mediation and other forms of ADR can be in resolving mainstream disputes. May I now invite Sultan to deliver his opening preliminary remarks. Sultan, over to you.
Thank you very much, Ajay, and thank you for the introduction earlier. And many thanks to the Oman Commercial Arbitration Center for organizing this webinar and for inviting me to speak in it. I'm pleased, of course, and honored to participate alongside such a distinguished panel. I will very briefly speak about the mediation landscape here in Qatar. So in Qatar, there are two jurisdictions. Firstly, the mainland Qatar, which is a civil law system. And secondly, the Qatar Financial Center, which is modeled on common law principles. And both the systems recognize the need for alternative dispute resolution and have their respective laws governing mediation and arbitration. I will very briefly discuss the mediation landscape in both these jurisdictions. So concerning the mainland Qatar, in November last year, the Qatari government enacted law number 20 of 2021, which is popularly known as the mediation law. The law regulates the mediation process and provides for the role of the mediator, who can be either an individual or an eligible corporate entity, and it empowers the local courts to refer a dispute to mediation, subject, of course, to the agreement of the parties, and lays down the requirements for a settlement agreement. Likewise, in the QFC, Qatar Financial Center, the Qatar International Court and Dispute Resolution Center, popularly known as the QIC-DRC, has its own mediation rules and mediation center. the parties can either directly approach the court, the Qatar International Court's registry, referring their disputes to mediation, or the Qatar International Court or the regulatory tribunal can refer a dispute to be resolved by mediation. In fact, in the QFC, there are many small claims by employees for unpaid salaries, bonuses, etc. These disputes, in my view, are very well suited for mediation and should greatly benefit from the Qatar International Court's measures for developing the mediation center. Also, the Qatar International Center for Conciliation and Arbitration, popularly known as KICA, which is a local and popular alternative dispute resolution center in Qatar, provides a detailed mechanism for conciliation and mediation. Even in specialized spaces, such as the Qatar Sports Arbitration Foundation, there is a mediation division with its own rules to facilitate the amicable dispute resolution among sports-related bodies governed by the Qatar Sports Arbitration Foundation. So as you can see, alternative dispute resolution is encouraged in Qatar at every step, not least, of course, because of the benefits mediation can have to the adversarial process, whether it is arbitration or litigation. I'll stop here and probably address any other questions later. Thank you.
Thank you, Sultan, for giving us a very brief insight into the mediation landscape in Qatar. And now may I invite Gordon Nardell, Queen's Counsel, to please give us his preliminary remarks. And I believe Gordon was part of a very exciting project of the Chartered Institute of Arbitrators. And there was a report which was released very recently. So I leave it to Gordon to give you a good insight into that intellectual exercise of which he was an author. Gordon, over to you.
Well, many thanks indeed, Ajay, and thanks very much indeed to the Centre. An enormous privilege to be invited to make these introductory remarks on the Chartered Institute of Arbitrators Professional Practice Guideline on the use of mediation in arbitration. Indeed, it was a privilege to be asked to work on that project. Let me just indicate, first of all, what the Chartered Institute's Professional Practice Guidelines are. They are not rules, they're not prescriptive, rather they're short documents which are sources of advice and support for practitioners, not just arbitrators, but mediators and also parties and their representatives. And the idea of a Chartered Institute guideline on the interaction between mediation and arbitration isn't new. The Institute first published a guideline on exactly that topic in 2011. But the landscape for mediation, ADR generally, and its interaction with arbitration has changed beyond recognition since 2011. There's been a whole series of changes in the culture of ADR and arbitration. We've had developments such as the Singapore Convention. Very importantly, the courts in many jurisdictions have leapt ahead in the way they accommodate mediation in their processes. So it was important for the Chartered Institute to update its thinking. And when we were sitting down and working out what needed to go into this document, above all, we decided this needed to be an holistic document. It needed to treat the topic as a whole. And I'm afraid here comes the soundbite. That holistic treatment had three parts: whole process, whole profession, and whole planet. Well, what do we mean by this? Well, first of all, whole process. We wanted to set out the ways in which mediation can interact with arbitration across the whole process, from the inception of a dispute right to the very end, and award and even post-award stages, and set it out in a logical order. whole profession, not just arbitrators. The Chartered Institute has a growing and very important mediation practitioner cohort, and we wanted this to be a resource for the whole dispute resolution community. And then whole planet. Well, what do we mean by that? Well, first of all, the Chartered Institute, although it's headquartered in London, is in no sense an English institution. It's a global institution, and it sees itself as very much part of the global dispute resolution community. So we wanted to write this document in accessible plain English as far as possible, tailored to an audience, many of whom would not have English as their first language. I hope we've succeeded. One of the techniques we used for ensuring this was a clear and comprehensible document was to try to avoid jargon. And so that means, although inevitably we've referred to some of this alphabet soup of med-arb and arb-med-arb, med-arb-med and so on, we've treated substance as being far more important than labels. And I think Sherina captured this rather well when she was describing these things as really on a whole continuum of techniques that the parties are free to use. They can jump in and out of mediation and arbitration at different stages as suits them and as suits their dispute. And so the guideline is designed very much to support that concept of a whole spectrum of techniques used at different stages of the process. We also wanted to ensure that the content of the advice in the guideline speaks to parties and practitioners from a whole range of different legal and importantly different business traditions. And that's forced us to deal with some rather thorny issues, including the rather tricky issue which Sherina flagged, namely the circumstances in which it is or is not permissible or advisable for the same neutral to accept appointment as mediator and arbitrator. This is one of those areas where the boundaries of acceptability and advisability are highly mutable and depend crucially on where your dispute is taking place, where the parties are from, and in the context of arbitration, where you're likely to enforce your award. Now, I have to say the concept of same individual accepting appointment as mediator and arbitrator is probably a topic for a whole webinar in its own right. So I just touch on it as an indication of the kind of issues we wanted to cover. So those who are interested in it can see how we've tackled it in section 8 of the document. So we want this to be a living document. We want it to continue to grow with the experience of those who use it. It's only a short document, it's 8 pages long, so please do read it. But more importantly than that, please do use it and let the Institute have your feedback so that in 3 or 4 years' time, when we come back to this topic and review the guideline, we're doing it on the basis of the living experience of practitioners. So I hope that's a helpful introduction to our work, and thank you very much indeed.
Thank you, Gordon. May I now invite Sriram, last but not the least, to deliver his inaugural preliminary remarks on the topic. Sriram, over to you.
Thank you, Ajay, and my thanks to the Oman Commercial Arbitration Center for this very kind invitation. I was sitting here thinking, 30 years back, what did this dispute resolution landscape look like? And I think you'd agree with me that it was a picture of total warfare, right through. Everybody who had a case went to a lawyer, every lawyer escalated it. You went to one round of court, escalation, another round of court, escalation. And at the end of it, if there was a survivor who won, he really didn't think he'd won. I've seen plenty of cases where both sides thought they'd lost. And they lost out on, on many things, on time and cost and relationships and family. And then comes mediation, which is as different from adversarial as chalk is to cheese, because this is completely consensual. Your mediator doesn't decide, but helps the parties to move to a settlement, which they can both accept. There is no risk, there is no fear, there is no tension. What has mediation done? It has brought into the dispute resolution process a humaneness I don't have the time. Where do we sit? It has brought a humanness into the process because everything about it is human. It is talking, it is communication, it is understanding the other, it is looking at your long-term interest, but also looking at the position of the other. Walk a mile in the other person's shoes, the mediator will tell you. And then it is sitting down to see how both of you can find solutions. Instead of attacking each other, both of you are jointly attacking the problem. It ticks off every box that you want. It ticks off the box on time because it finishes incredibly quickly. It ticks off the box on cost. It ticks off the box on sustainable solutions rather than court verdicts which get you nowhere. It ticks off the box on risk. It ticks off the box on relationships, restoring relationships, salvaging relationships. Chief Justice Suresh Menon of Singapore has a wonderful phrase. He says, what's not to like about mediation? And mediation truly has brought us to the correct meaning of what ADR is. ADR is no longer alternate dispute resolution. ADR is appropriate dispute resolution. The concept that for every kind of dispute, there is a good method of remedy. It can be litigation, or it can be arbitration, or it can be mediation. And by slotting disputes like this, we have truly, I think, arrived at the maximum optimal capacity and use of the legal system. And mark my words, when mediation is introduced, it's like brush fire. 30 years back in India, when I started to speak on mediation, everybody thought I was talking about meditation and a change of career. In 30 years' time, we have moved mediation across India in all our courts. We have a few thousand mediators, they mediate a few lakhs of cases. And today we are on the verge of a mediation law, which will mandate that before a case goes to court, it must be compulsorily mediated. And that even if you need interim orders, you will go to court, get your interim orders, but go back to the mediation table. This is how fast mediation can move when once it is engrafted onto a system. And today we're talking about something very important. We are bridging the adversarial and the consensual in the process that we talk about today. When we link arbitration and mediation and see how the two can be combined. And Sherina spoke so eloquently of how at multiple stages in arbitration, you can shift to mediation. But I will tell you that you can do the reverse as well. That very often in mediations, you will have one unresolved percentage or issue which the parties cannot cross. And that is perfect to refer them to an arbitration which can be quickly structured. You choose the arbitrator, choose the time, structure it, send them off, get the result, and bang, you're complete. So it brings in flexibility, and most of all, I think it is user-oriented. At the end of the day, we do well to remember that we serve, whether we are judges, lawyers, arbitrators, and mediators. But it's the user who matters, and mediation brings the user foremost. Thank you very much, Ajay.
Thank you, Sriram, for sticking to the time limit and for that very insightful remarks into your own experiences with mediation, which comes from 30 years of being part of that process in what is considered to be a highly litigious part of the world. So, ladies and gentlemen, those were the preliminary remarks from our 4 distinguished speakers. And now for the next 25 to 30 minutes, what we endeavor to do is to open the floor to what we call open forum discussions, where we'll have pointed questions, put to the panelists, which will form a sort of a primer for the discussions over the next, the next 20 odd minutes. And this is also, ladies and gentlemen, an opportunity for you to use the question and answer box at the very bottom of your webinar screen to type in your questions. Please do not wait for the very end. Please start typing your questions so that we can, at an appropriate time, address them to the speakers. Now, Sherina, I have a question for you. In your preliminary remarks, you used the word culture in international disputes. Now, considering that there are these different types of cultures in international disputes, in what way do you think this culture bit influences the outcome of the mediation process?
Thanks, Ajay. The globalization of business has created incredible opportunities with people from all corners of the globe, from different cultures, different backgrounds, communicating with each other to do business on a daily basis. And it's been amazing to see how global the world today is. In fact, let's just look at our own panel today. We're all from different cultures. Around the world, people are communicating their intentions not only through the words they speak, but through tones, gestures, and body language. And these signals are often made and interpreted subconsciously. As you know, in an arbitration, the outcome will either go one way or the other. A party could either win or lose or somewhere in between. But mediations are far more nuanced as the outcomes are within the party's control. A high context culture is communicated implicitly or by code. So one needs to listen carefully for verbal signals and read the meaning of the other party's words in the context of the negotiation. So certain words may, for example, evoke a positive response in some cultures, but those same words could elicit actually a negative response in other cultures. Interaction can be much more formal, and social position is extremely important. So sometimes in initial negotiation meetings, for example, a person's status or organizational position can determine how much they say or actually contribute to the mediation or the discussion. In contrast to the high context cultures or the low context societies like the US, where people tend to be direct and say what they mean explicitly. Culture also dictates whether parties are amenable to a joint open session or how high one party is likely to start with their opening offer, how quickly people move from problem solving into bargaining. In fact, interestingly, in one mediation where I was acting as counsel to a party from a particular Asian jurisdiction, my clients flew to the UK 3 days before the mediation, only for the purpose of role-playing with me the entire mediation process. So one of us acted as the mediator, a couple of the clients acted on the other side, pretended to be the other side. Some of the clients pretend to be on the side that I was representing. And we've role-played every scenario, including how they would walk into that mediation room. Should they carry a Norton Rose Fulbright notepad in their hand, so that it would show that they've engaged a heavyweight law firm to represent them? Would this signal too aggressive a posture, or would it actually be the right signal to be giving the other side? Every single detail was thought through. And needless to say, we actually got an extremely positive outcome from that mediation. So I hope that's answered your question.
Thank you, Sherina. It does beautifully. And taking off from what Sherina had to talk about culture in international disputes arbitration, I have a question for Gordon now. Gordon, your practice to a large extent is acting as counsel in arbitrations and also sitting as arbitrator. Now, when you don the role of an arbitrator, how comfortable do you feel taking the initiative in suggesting ADR arbitration to the parties?
This is interesting, and Ajay, you're right to treat this as a question about culture, because one of the problems in arbitration, possibly less so in mediation, because it's developed so much more rapidly in recent years, but the problem with arbitration is the kind of time warp. It's the arbitral community, those who sit regularly as arbitrators, not moving on as quick, their expectations and understanding of what's acceptable, not moving on as rapidly as I think the expectations of many of the parties, those who are doing business, those whose disputes is being determined, the pace at which those expectations have moved on. And I think there may be many arbitrators who somehow think of it as not their role to suggest anything other than the proceedings steam ahead via procedural order number 1 through witness statements and disclosure to an award and enforcement. And I think it's very important to challenge that culture and ensure that arbitrators understand that it very much is their role, when appropriate, to be proactive in suggesting that the parties might negotiate or might use some form of formal ADR process. And this is where advice and resources like the guideline come in, because that's there to provide, as it were, cover for the arbitral community to make it clear, actually, it is okay, it is acceptable to be proactive. And it's not just the CIARB now that has this in print. If you look at some of the arbitration rules of many of the long-established institutions, such as the LCIA and ICC, all of those make clear that their expectation is very much that the arbitrator may, where it's appropriate, take the initiative. So I think it's important that the culture of arbitration doesn't get stuck in a time warp, that it moves along with the times and understands that it can be the arbitrator's role. And so as an arbitrator myself, I'm very comfortable making the suggestion where it's appropriate for the parties perhaps to think about talking to each other about particular issues. And I'm very happy where necessary of my own initiative to make procedural space in the arbitration for that to happen. And this happened recently where I was sitting as arbitrator, and one party who was unrepresented started effectively to negotiate in the face of the tribunal. And of course, the risk is that you end up with unfairness because that party might make unguarded admissions, which the other party might seek to rely on. And so I suggested the parties ought to perhaps take a little time to see whether they might want to negotiate. And I extended a couple of the deadlines of my own initiative in the procedural timetable to allow space for that to happen. So I think it's very much for the arbitrator to feel comfortable in this role. And if the CIARB guideline plays a small role in promoting that, then I hope it will have succeeded.
Thank you, Gordon. And now, Sriram, over to you. In one of our conversations earlier, you talked about shifting track, the process of shifting track in the dispute resolution process. Now, do you think this is something arbitrators will like?
It may not be something they like automatically or very happily, but I think they better get around to liking it. Nobody is going to be perpetually happy swimming against the tide. And I think, if an arbitrator has a reputation for being the neutral who at the appropriate time tells the parties, I think you should try mediation now. I'll keep proceedings on hold, try mediation, and let's see, if it works. I hope it does. I think that arbitrator will win bonus points for party welfare and upholding the higher standards of the profession. And I'm pretty sure that in time, a good arbitrator with good enough training and a slight change of attitude will become a good mediator. So, there's another avenue over there. But as I said, the tide is on, and what, Victor Hugo? Nothing is as powerful as an idea whose time has come. So mediation is here to stay. Arbitration and mediation will work in tandem. I foresee a day, if I may make a prediction, I foresee a day where at the conclusion of an arbitration session and the final arguments, you will have a mediator attached to that panel, sitting with the arbitrators and hearing the case. The arbitrators will then retire to write the award, And the parties will then sit with the mediator to see in the meantime if they can settle. I'll tell you something else. I think institutions will, when they are allocating arbitrators to cases, will have the allocation of a mediator on standby, so that at any time the parties want to talk settlement, they have the person allocated. They don't waste time. These things will happen. And as to whether people like it or not, can I quote an old rhyme? It says, I'm the parliamentary draftsman, I make the country's laws, and of half the country's litigation, I'm undoubtedly the cause. One more. I employ a kind of English which is hard to understand, and though the purists don't like it, all the lawyers think it's grand. Now I'm going to take this off and put it here and say, even if the arbitrators act like purists and don't like it, all the users will think arb-med and med-arb is grand, and they will carry the day.
Thank you, Sriram. Thank you very much. In fact, that's some food for thought for us at the Oman Commercial Arbitration Center. Your suggestion about having arbitrators on standby, I think, is something that Dr. Moosa and the executive committee, I think, will be very happy to consider, in one of their next meetings. And perhaps, maybe, if you have the time, we could call you to make a presentation of sorts, to the executive committee to give us a little more insight into the mechanics of the process. Absolutely.
Dr. Moosa knows exactly what will make me come.
So anyway, I have a follow-up question, Sriram, now. How, coming back to the shifting track thing, how useful do you think is supporting legislation? Because I know for a fact in India, Section 30 of the Indian Arbitration Act, correct me if I'm wrong, seems to suggest that it shall not be incompatible with the duties of an arbitrator to suggest the resolution of a dispute through mediation. So do you think enabling legislation, supporting legislation can play a role?
I think so. I think it always, I think the two things work together. One is the culture, and the culture comes in, host of myriad factors which bring about, a culture shift, partly events like this. And the other is legislation. And I remember when we started mediation in India, we had very little by way of legislation for mediation. We had the beginnings of it in the Civil Procedure Code. But very quickly, we had a couple of judicial precedents which said that even if a party says, I don't want to mediate, a court has the power to direct that party to go to mediation. Number one. Number two, that while a court will not look at what happens in the mediation, the court will take seriously any complaint or any allegation of not mediating in good faith. And that's all you needed, really, to get parties serious about the time at the mediation table. So it is the culture, it is the legislation, but it is also how judges actually, you get messages from judges. Like at the beginning, a judge would say, well, what is mediation or why mediation? And then it became, well, let's look mediation, the instant case. Now, uniformly, even without legislation, actually, the judges will say, why aren't you mediating? So it is legislation, it is the way judges respond, and it is the culture at large.
Thank you, Sriram. Now, I have a question for Sultan. Sultan, in your preliminary remarks, you had alluded to the fact that mediation can benefit the adversarial processes like arbitration and litigation. So can you elaborate a little more on that, please?
Yes, of course, Ajay. For a mediation to be successful, or say to be at least meaningfully engaged, it requires the parties to explore their respective best alternative to a negotiated agreement, which we call for short BATNA. For example, in the construction sector, for a party to arrive at a BATNA essentially entails conducting a thorough, you may say, like a peer review analysis of its claims. So the parties may realize that their time-based claims are not straightforward, but marred by concurrent delays, for example. Likewise, in prolongation costs claims or disruption cost claims, sometimes they are not supported by sufficient documentary records. So the claims at this stage start looking very different from what the party felt that it was originally, or they were originally. A meaningful mediation exercise allows the parties to reflect on their claims and to do so honestly. This greatly benefits the arbitration because the parties, or the litigation, because the parties will be realistic in bringing their claims if the mediation fails. This not only reduces the arbitration costs for the party, but also minimizes the risk of an adverse cost award if the claims in their exaggerated form were to fail eventually. Even as a strategy, it makes sense to approach the mediation wholeheartedly with that, I mean, properly ventilating your claims in the request for mediation. This has a twin effect of firstly avoiding an admissibility challenge by the other side in the potential arbitration, and secondly, the request for mediation can be easily converted into a request for arbitration if the mediation was to fail.
Thank you, Sultan. I have a question for Gordon now. Gordon, the courts in many jurisdictions have now become increasingly sophisticated in steering disputes towards the ADR process. For example, there is a law in India called the Commercial Courts Act, by which pre-institution mediation has become compulsory in commercial matters. And I'm sure there is something to that effect even in the United Kingdom. So is arbitration now playing a catch-up game, when it comes to steering towards ADR, parties to ADR?
Well, there's no doubt that arbitration has a great deal to learn from the way courts in different jurisdictions have accommodated and integrated ADR into their processes over the last 10 years or so. But it's important to learn from perhaps those initiatives that have been less successful, as well as those that have been successful. And it's interesting you mentioned the Indian example of requiring the parties to attempt ADR of some sort at the pre-commencement stage, because here in England and Wales, our Civil Justice Council at the end of last year produced a report which recommended a revamp of our pre-action protocols so that there may be sanctions if including quite swinging sanctions, such as striking out proceedings, if parties haven't taken a proper opportunity to attempt settlement before they come to court. But there is a problem here. Some of these initiatives, and I'll use England and Wales as an example, are slotted into the court's case management functions. And the idea of active case management was a very welcome one when it was introduced, because a number of years ago, it was very easy for parties to obstruct and derail court process. So if you had an obstructive defendant, it was very easy to prevent cases from proceeding. And the courts had had enough of that. They'd had enough of parties wasting and duplicating costs. And so they introduced active case management. What you now hear from many commercial practitioners in English litigation is that the process is over-managed. And I think there's a danger in over-managing the way you integrate ADR into court processes and similarly into arbitration processes. And one of the great benefits of ADR and allowing the parties to choose when to attempt it is that timing is absolutely critical. Insisting that parties explore mediation at the beginning of the process may not be very helpful. The parties may not know enough about their own, certainly the other side's case, to make informed decisions about litigation risk and the value of a settlement as against the value of incurring those costs and going further. And so this rather fashionable insistence on making the parties go through the motions of ADR early on may not be all that helpful, and indeed it may be counterproductive, because the trouble is, you've then shot your bolt. You've made the parties go to ADR. It doesn't work. They don't like it, and they don't attempt it again. Those jurisdictions where the courts have been most successful in integrating ADR into litigation have been those where there's a degree of sensitivity to the timing. The courts of New South Wales have played a blinder here. I was on a webinar panel a few months ago with a retired New South Wales judge who was explaining how the judges at each level of the New South Wales jurisdiction are trained in spotting the optimum moment for suggesting to the parties or urging the parties or staying proceedings and steering the parties into ADR. So it's important that what arbitration learns is, yes, the importance of integrating ADR into its processes, but like good comedy, timing is everything. So it's important that arbitrators are sensitive to when it's appropriate to suggest ADR to the parties and not adopt a one-size-fits-all approach.
Thank you, Gordon. So I think, in my view now, I think when you're looking at steering parties in arbitration towards mediation and other forms of ADR, I believe a big responsibility, I think, lies with institutions. I think arbitral institutions also do have that responsibility in promoting the use of mediation in arbitrations. Now, we have Sherina here. Now, Sherina is on the board of directors of the London Court of International Arbitration. So, Sherina, now, given that you wear the hat of a board member of the LCIA, do you think, what is your view on the suggestion that arbitral institutions should promote the use of mediation in arbitrations?
Thanks, Ajay. I think arbitral institutions should promote the use of mediation in arbitration. And in fact, many of them do have their own mediation rules. I know you mentioned the LCIA, and they've come out with revised rules, and there is, mention of mediation there and encouragement of mediation. Take also, for example, the ICC rules, and you look at Appendix 4, which states that the tribunal may, at an early stage of proceedings during a case management conference, encourage parties to consider mediation as an option. It also further suggests that tribunals may inform the parties that they are free to settle all or some part of their dispute by any form of amicable dispute resolution methods, such as mediation under the ICC ADR rules. Now, there's the SIAC and the SIMC, which jointly promote a combined process that involves different neutrals in arbitration and mediation stages. So in the SIAC SIMC arb-med-arb protocol, a party could start arbitration, proceed to mediation after the appointment of the tribunal, and revert to the tribunal to incorporate a settlement agreement into a consent award. Unless parties agree otherwise, the arbitrators and mediators are different people. They are separately and independently appointed by the SIAC or the SIMC under the applicable arbitration and mediation rules of each of these centers. So, of course, ultimately, whether to use mediation or not should be definitely left to parties to decide in accordance with the consensual nature of mediation, I think by arbitral institutions incorporating mediation options, parties are provided with a greater choice and a menu and opportunities for less expensive, faster and better outcomes, minimizing the risk of the process itself becoming part of the problem.
Sure. Thank you, Sherina. I had one last question for Sultan. Now, Sultan, you had spoken about the fact that mediation has not been very successful in resolving disputes in the construction and infrastructure sector in Qatar. Now, can you probably enlighten us as to what perhaps are those reasons why mediation has not been too successful in that sector in your home jurisdiction?
Yes, sure, Ajay, thank you. So the pre-arbitral or the pre-litigation steps and the construction contracts in Qatar typically provide for negotiations between senior management, expert, or engineers' determination, or a reference to a dispute adjudication board if FIDIC terms are adopted, or even mediation. In my experience, most of the time, the parties tend to approach pre-dispute settlement mechanisms as ticking box exercises before commencing the formal proceedings, such as arbitration or litigation. This approach risks the parties being locked into their positions and not meaningfully exploring their respective interests. In many instances, the engineer is either the employer's employee or an agency appointed by the employer, who is not perceived to be acting independently. If the contract provides for the engineer's determination, the engineer either parrots the employer's line or fails to give a reasoned decision. This further increases the trust deficit and creates animosity, thereby dramatically reducing the chances of an amicable settlement. For claims such as variations or an extension of time, prolongation, disruption costs, the parties need to have a detailed analysis to understand their position and interest before engaging in mediation. However, in practice, it is often not applied. Many times, the employer doesn't want to pay straightforward sums like the retention amount. So the employer fails to appreciate that it will have to pay more potentially and eventually if it were to lose the arbitration or litigation. So therefore, the parties attempt mediation with unrealistic expectations without understanding their interest, which becomes a mere formality to be completed before the formal proceedings are instituted. Having said that, I do believe that with the new mediation law and with the ratification of the Singapore Convention, the outlook of the parties in the Qatari construction industry towards mediation will probably change. It will incentivize the parties to adopt mediation as a preferred dispute resolution mechanism compared to other forms of dispute resolution methods such as engineers' determination or dispute adjudication board.
Thank you, Sultan. That's a very interesting insight into the reasons why mediation has not been too successful in Qatar. We're running a little short of time. I think now is the time that we take a few questions from the audience. We have a question, in fact, the same question asked by two different gentlemen. Engineer Gali Al-Masali and Ethelward Mendes from Goa they're asking pretty much the same question. Is it proper for a mediator to become the arbitrator in the same dispute? So maybe Sherina, can I ask you to perhaps give us your views on the appropriateness of a mediator to become an arbitrator in the same dispute?
Ajay, I think a lot will depend, well, on the parties as well as on the person who's accepting that appointment, because it depends, as I touched upon earlier when I was speaking, how much has been disclosed that's confidential, damaging during that mediation process. Are both the parties comfortable that that same person who's listened to that open, without prejudice, what would usually be without prejudice dialogue, are they happy for that person to be sitting there judging their dispute, or is that going to be challenged later on? That the person was actually biased because they'd heard all of this information, and it could be a trap that, you know, they've agreed to have that same person there. So I think, and also then it's the comfort of the person accepting that appointment as well, because it is a risk. I mean, one is, yes, there are benefits because obviously you've delved into the dispute and you've already heard the offline version of it. And now you're hearing the more formalistic online version of it, which you would normally as an arbitrator. So it's just such a double-edged sword. Would I personally be comfortable? I'm not sure. But I know someone who actually did, a person who's very senior in the UK and who sat as a mediation, who sat as a mediator in a mediation, and then accepted the appointment as an arbitrator. And that person was very uncomfortable at the start of the process, but actually came away saying it worked fine and it settles and there was no challenges and it was seamless. So I think it just depends situation to situation.
Sure. Thank you, Sherina. And maybe I'll get Sriram to share his views on this, because traditionally there's always been two views. There are two schools of thought. You have the Chinese school of thought, where the concept of double hatting, the mediator transforming into an arbitrator and vice versa, is very common. And then you have the rest of the world where it is very uncommon for a mediator or an arbitrator to transform into a new avatar. So Sriram, given the fact that you also act as an arbitrator, but with a large experience in mediation, on the fundamentals of mediation, do you think it's incompatible with an arbitrator to transform himself into mediator and vice versa? Your views, please.
I think so. I think you are at danger of breaching confidentiality.
Sure.
If the same person acts as both the arbitrator and the mediator. So I would completely advise against it. I don't do it, but since there must be an exception for every rule, I did it once, and may I tell you about that? I'll try and take a couple of minutes. I was appointed as an arbitrator by the Chief Justice. When the parties left the court, he told them, tell Mr. Panchu I want him to act as mediator also. They came and told me that, and I had the biggest dilemma, I said, how the hell am I supposed to, mediate when I'm the arbitrator? But as everybody knows, you can't say no to Chief Justices. So this is what I did. I heard the parties in full as an arbitrator. I wrote out my award. I brought it to a session convened for this purpose. I kept it on the table and I said, here is the award. Do you want me to mediate? If you do, you can tell me whatever you want to in confidence. It is not going to change the award if the mediation fails. They said yes. It was a case where the claim was against an old lady, part of a family. She had signed away her rights to the family property, and later on realized that she hadn't got a proper share, so she refused to go on with the deal. Everybody else, the builder, the rest of the family, and the people who bought flats sued her, and I will say they sued her for 80 million. I thought as an arbitrator that she had a case. She hadn't been given a proper share, but she had a horrible legal case. She was out of time. She was out by estoppel. So I ruled against her, but I was sympathetic to her. So I said she must pay damages of 20 million and must sign all the papers. That's my award. She must pay 20 million. I started the mediation. The builder comes in and he says, I have no part in this, but this is my son's first business with me. I don't want a black mark. I think the lady wasn't given a proper share, and I don't want this black mark, although I'm not really involved in this. I'm prepared to give 25 million. The nephew came, the guy who organized this, and I asked him one question as mediator. I said, this is your aunt. If this was your mother, would you say the same thing? He said, give me half an hour, sir. Within half an hour, the nephew, the builder, the other flat owners trooped back in and said, we are prepared jointly to give her 50 million. So here is this lady. She starts the day 20 million down in my award. 12:30, she's 50 million up because of the mediation. And that case to me has always underscored that because you bring in completely different factors in mediation, like a builder saying, I don't want my son to start with this as his first enterprise. And family factors, you bring it in. And you completely change the complexion. That was the only case which I did. I mean, that's the first time I tried that case. And now I have a whole lot of arbitrations where people come to me for the sole purpose of not my wisdom in arbitration, but waiting for the time when I say, do you want to settle this? So.
Thank you, Sriram, for sharing that interesting war story. Now, talking about war stories now, maybe Gordon, do you have any interesting experiences, war stories to share? Any takeaways, from these interesting war stories?
Thanks. It's just very briefly on the role of lawyers in mediation, because Sherina touched on this. I was really quite intrigued by Sherina's tale about wargaming the mediation in advance. Working out whether someone should carry a Norton Rose Fulbright pad on full display and so on. And it's very interesting because it raises an important question about the benefits or otherwise of lawyers playing a role in mediation. I think what it's crucial to remember about mediation is that what a good mediator will do is get the parties talking to each other. And if you're a lawyer, if you're counsel for a party, and you're serious about the mediation, sure, if you want to derail the whole process for whatever reason, it's very easy to do so. But if you're serious about the process as a lawyer, you need to think very carefully about your own role, how you as the lawyer are going to facilitate that essential process of a corridor of communication between the parties themselves. And it's not so much one raw story as a whole series. I mean, my advice to my clients is that sure, if you want me to turn up at a mediation to represent you, I'll be happy to do so. But my advice is don't. If you go along tooled up with your silk, that does not really look like a party who's serious about settling. Sure, there may be good reasons why you want a senior lawyer available to advise you on some of the nuances that emerge of some feature of the other side's case or some challenge to yours. But I'd be much happier sitting on the end of the phone than going along to the mediation itself. And on one occasion when the client insisted and said, well, I want you to come along, please do, we turned up. And in fact, unbeknown to us, the other side had decided to dispense with their lawyers entirely. And they were rather aggrieved that we'd turned up with our heavy battalions. But the client was adamant, he wanted me there in the plenary session. And so what I did was I deliberately moved my chair about 30 centimeters further away than it should have been from my party team. And I sort of sat with my head turned away, my head down, just to make it clear, I wasn't the mouthpiece for my client. This was a conversation that my client needed to have with the other side through the mediator. And so through the body language and the situation, I did my best to facilitate that conversation. I think this question of, there's quite a lot of nuance and subtlety to how the players operate in the context of mediation. But the crucial thing is to remember, you're there to facilitate a conversation between the parties via the mediator. That's the critical point.
Thank you, Gordon. I think we have time for just a couple of very short questions. Sultan, do you have any interesting war stories to share? on the interface between mediation or arbitration or mediation successes, failures?
Well, I do, and it's unfortunately a failure. It's a very recent case. Since I work closely with the construction industry in Qatar, I will share my very recent experience on an ICC mediation concerning a prestigious project in Qatar in a multi-million-dollar dispute. So we represented a client in a complex construction case that had not only regular time-based claims, but also involved many disputed technical matters about the execution of the work. Unfortunately, as I said, the mediation failed in this case. However, we have a lot of positives and some lessons as well. So we worked with our client and the claims consultant to develop the best alternative to a negotiated agreement, or what we call a BATNA. Naturally, the results was that the claims looked very different from what was contended in the original disputes by our clients. There were a few new claims that were not considered previously. Still, by ventilating them in the mediation, we minimized the risks of an admissibility challenge for those claims. So you will see a mediation, irrespective of its outcome, complements the adversarial proceeding in this case. For me, the lesson from this is that the parties should be prudent in their choice of the mediator and should work together to agree on a mediator mutually rather than have a third party appoint a mediator. This is not a criticism, but in my view, it increases the chances of a settlement if the parties jointly choose the mediator. This is more so when the dispute relates to technical matters of some complexity. It will help if the mediator's profile is such that the parties can repose their trust in the mediator. So far, we have seen that mediation has not. Mediation has not been very popular. But as I said earlier, I think there is a trend to change that going forward. Thank you.
Thank you, Sultan. Sadly, we don't have the time to ask Sherina to share a war story. But in lieu of that, I have an interesting question for Sherina. Sherina, now this is a Miss Universe type of question. So here goes the question. Post-retirement, Sherina, if you were given the option or the opportunity to work exclusively as an arbitrator or exclusively as a mediator, which option would you choose and why?
Ajay, do I have to choose one option? Why can't I have a hybrid option, which is both? I don't like
well, I think with that answer, probably you would have bagged the Miss Universe crown, because I think that in a way, I think sums up our discussions for today, that arbitration and mediation are not really I think the compatible processes which can be merged and used to complement each other in providing an acceptable, efficacious, and speedy dispute resolution process for end users. So, ladies and gentlemen, on that note, may I take this opportunity to thank our distinguished speakers, Sherina Petit, Sultan Abdulla, Sriram Panchu, and last but not the least, Gordon, for contributing to the success of this webinar. As you all know, this is our very first webinar, but I can assure you that this is the first in a long line of webinars that will be hosted by the Oman Commercial Arbitration Center. I would be failing in my duties, ladies and gentlemen, if I were not to acknowledge the role played by my colleagues at the OAC, especially the leadership of Dr. Moosa Al-Azri and Moosa Al-Karusi, Mohammed Al-Amri, Abir and ML for their outstanding support behind the scenes in putting this whole event together. So I greatly appreciate your support, in organizing and successfully executing this event. And last but not the least, a big thank you to all of you attendees who registered and attended this webinar. Shukran Jazilan. We greatly appreciate your support to this initiative of the Oman Commercial Arbitration Center. And we look forward to welcoming you to the next episode of our 2022 webinar series. So ladies and gentlemen, Sayyidati wa Sadati, stay safe. And I hope all of you have a fantastic weekend ahead. Ma salama.
Thank you.
Thank you.
Thank you. Thank you. Thank you.